Donald Trump filed his opening brief in the appeal of the federal judge Tanya Chutkan's denial of his motion to dismiss the indictment in the Washington, D.C. criminal case on absolute presidential immunity grounds. Donald Trump filed with under an hour to go before the December 23rd deadline set by the three-judge D.C. Circuit Court of Appeals panel. Donald Trump is arguing in his opening brief for king-like powers of the presidency. Donald Trump basically says that anything he does or did while he was in office, while he disgraced our White House, he should be immune from any criminal prosecution at all. He states that the judiciary has no role whatsoever in resolving any criminal case regarding the office of the presidency. In essence, presidents could commit any criminal act, and according to Donald Trump in this brief, there would be no remedy at criminal law. And Donald Trump argues the only remedy that would exist is the impeachment clause, whereby a president could be impeached by Congress and then convicted by the United States Senate. And he says that's the only remedy when it comes to United States presidents committing crimes. Now, obviously, Donald Trump's legal arguments here are beyond frivolous. Donald Trump is not going to prevail before the D.C. Circuit Court of Appeals. Special counsel Jack Smith will file his brief on December 30th. Donald Trump's reply is due January 2nd of 2024, and then the D.C. Circuit Court of Appeals has already set oral argument on this appeal for January 9th. As I've explained in prior hot takes that I've done on this issue, one of the reasons I believe that the United States Supreme Court denied special counsel Jack Smith's petition for certiorari on a direct appeal before the D.C. Circuit Court of Appeals rules is because the D.C. Circuit Court of Appeals set this really expedited briefing schedule, and I think the Supreme Court just wants to wait until the D.C. Circuit Court of Appeals rules against Donald Trump and affirms the federal judge, Judge Tanya Chutkan's order denying Donald Trump's motion to dismiss the indictment on absolute presidential immunity grounds. Just go through Donald Trump's opening brief here so you can see what his arguments are, how egregious, how frivolous, and frankly, how dangerous the arguments are. And then let me tell you what I think we can expect from special counsel Jack Smith's reply that will be filed in about 7 days. So here's the opening brief of defendant Donald Trump. His lawyers continue to call him president. He's not. He's a former president, and he's disgraced that title. He goes on to basically say some of the related cases here. Donald Trump cites the Blassingame v. Trump case as a related case, and United States v. Trump, Donald Trump's appeal on the gag order. You'll recall the D.C. Circuit Court of Appeals recently affirmed federal judge Tanya Chutkan's gag order by and large on Donald Trump for making threats against court staff and family members of the special counsel's office and family members of the judge and court staff right there. Donald Trump has since filed a petition for an en banc review, meaning the whole D.C. Circuit Court of Appeals, all of the judges, not just the three-judge panel who ruled against him. One of the related cases here is also the Blassingame v. Trump decision by the D.C. Circuit Court of Appeals on December 1, 2023. And that's notable because in Blassingame, the D.C. Circuit Court of Appeals ruled against Donald Trump, said that in civil cases, he doesn't have absolute presidential immunity regarding the January 6th insurrection because his conduct relating to January 6th involved election activity and campaigning, and that's not within the responsibilities of Article 2 or any commander-in-chief roles and responsibilities. So the only other D.C. Circuit Court of Appeals case in a civil context says that Donald Trump's conduct relating to trying to overthrow the results of a free and fair election fell outside the outer perimeter of absolute presidential immunity. And here, in this criminal case, we already have the ruling by federal judge Tanya Chutkin. That's the trial court level, who said that former presidents do not have absolute presidential immunity for criminal conduct during the time where they are in office. And now that appeal is what we're addressing here. Donald Trump seeking an appeal from the denial of his absolute presidential immunity motion to dismiss. Going through Donald Trump's arguments and the summary of his arguments. I mean, this is the intro where he talks about, during the 234-year history from 1789 to 2023, no current or former president had ever been criminally prosecuted for official acts. That's the same line that he always starts with. First off, by trying to overthrow the results of a free and fair election official acts. That's just simply not official acts, but he tries to kind of couch it that way. And then the reason that no former presidents have been criminally prosecuted is because Donald Trump is singular in trying to overthrow the results of a free and fair election and then leading an insurrection against our great nation. The brief goes on to say, under our system, this is what Donald Trump's saying, under our system of separated powers, the judicial branch cannot sit in judgment over a president's official acts. That doctrine is not controversial. It was treated as self-evident and foundational from the dawn of the Republic, and it flows directly from the exclusive vesting clause of Article 2 in 1803. Chief Justice Marshall endorsed it, writing in Marbury v. Madison that a president's official acts, quote, can never be examinable by courts. The structure of our government, the text of the Constitution, and its early commentators, common law immunity doctrines, our political history, the Supreme Court's analogous immunity doctrines, and the policy considerations rooted in separation of powers all dictate that no president, current or former, may be criminally prosecuted for his, and he italicized this, official acts, unless he is first impeached and convicted by the Senate, nor may a president face criminal prosecution based on conduct for which he was acquitted by the United States Senate. The indictment against President Trump is unlawful and unconstitutional. It must be dismissed. And Donald Trump's just making that stuff up. I mean, number one, there's no such thing as official acts when you're engaged in criminal conduct. Why would a former president who, while they were in office, engaged in crimes, be able to do whatever they want? I mean, presumably take foreign bribes, kill somebody, rob a bank, and then say, oh, that was an official act. And clearly, as the D.C. Circuit Court of Appeals has already ruled in the civil context, the conduct relating to the insurrection involves election and campaigning activity. Interfering with the free and fair election is not within the province of Article 2 executive authority at all. Going through Donald Trump's opening brief here, he goes through the allegations in the indictment. He talks about the trial court's proceedings and then attacks federal judge Tanya Chutkin. And then he says in the summary of argument that there are 7 considerations why Donald Trump's view of presidential immunity from prosecution for official acts should be recognized here. Trump says, first, criminal immunity has deep roots in the separation of powers. No, it doesn't. It's not true. Criminal immunity deeply rooted in separation of powers. No, don't commit crime. Second, Trump argues the text of the Constitution through the impeachment judgment clause presupposes criminal immunity. Trump argues that the impeachment clause forecloses any other relief outside of impeachment and conviction in Congress. And then third, he argues early commentators on the Constitution, he claims, says supports this. They don't. Fourth, he says at common law, immunity from criminal prosecution was far more central to the concept of immunity than from civil liability, saying that crimes should be protected more than civil wrongs. That's just simply false. Fifth, the 234-year tradition of not prosecuting presidents. How about the 234-year tradition of not trying to overthrow free and fair elections and support terrorist groups like the Proud Boys and the Oath Keepers and support the January 6th insurrection, try to topple our government? Sixth, analogous immunity doctrines for legislators and judges, which are also rooted in the separation of powers. That's simply false. If he's referring to the speech or debate clause immunity, even there, speech or debate clause only applies to legitimate legislative conduct per the U.S. v. Gravel case, so that doesn't help him. Seventh, he goes policy considerations rooted in the separation of powers support the immunity. And then Donald Trump cites to the Nixon v. Fitzgerald case, which recognized the doctrine of absolute presidential immunity in civil cases, stating that conduct that falls within the outer perimeter of official presidential responsibilities, even if the conduct may otherwise be wrongful, is subject to civil immunity. But as I just stated, the D.C. Circuit Court of Appeals recently ruled in Blossingame that conduct that falls outside the outer perimeter, like election conduct and campaigning and trying to overthrow free and fair elections, is not within the outer perimeter, and thus absolute presidential immunity doesn't attach in a civil context, says the D.C. Circuit Court of Appeals. And as I've said, federal judge Tanya Chutkin, in her very well-reasoned order, explains all the reasons why the text, structure, and history of the Constitution does not support a doctrine of absolute presidential immunity in criminal cases. So then Trump goes through and makes all of the arguments there in more detail, and then basically says, by and large, his argument is that judges, the judiciary, can't touch him, that he's above the law, not arguing that he didn't do the conduct, just that he should be immune from engaging in criminal conduct. Now, if there's anything less American, if there's anything less rule of law than saying that presidents are above the law, I mean, tell me in the comments below, but it isn't. I mean, it's a horrible argument, both in terms of its legal reasoning, and it's just what a horrible thing to even assert. It's embarrassing to our nation. It's utterly disgraceful. Donald Trump is going to lose this argument. So next up, Special Counsel Jack Smith will file his brief on behalf of the government, and they're going to argue exactly what they argued in the lower court. And they're going to say, no, there's no such thing as absolute presidential immunity. It would be absurd. That would be king-like immunity. The very essence of why our Constitution was created was a rejection of the arbitrary criminal power of monarchs. So to say that you have that power would make absolutely no sense at all. Then expect Donald Trump to file his reply brief on January 2nd. We will hear oral argument, and that will be on audio recording. So we'll cover that here on the MeidasTouch Network. So make sure you're subscribed to hear that oral argument. It's going to be a scathing hearing. Trump's lawyers are going to get completely ridiculed by this 3-judge panel. And then I expect the panel to issue a written order within 5 to 10 days of that oral argument. So expect that if the oral argument is coming up soon, expect by January 20th or so that you will probably get a written order. And then after Donald Trump loses before the D.C. Circuit Court of Appeals, the next step would then be certiorari before the Supreme Court. Rather than skipping the D.C. Circuit Court of Appeals, the D.C. Circuit Court of Appeals will rule. Donald Trump will try to delay and not file the certiorari petition right away. He will say he needs to consider it. He'll ask for probably 60 to 90 days delay because his whole goal is to delay. And then Special Counsel Jack Smith will have to seek immediate certiorari review by the Supreme Court. The Supreme Court will respond to Jack Smith. We'll order that Donald Trump respond within a fairly short period of time. And then we'll see if the Supreme Court hears oral argument and when. And then at the same time, what we want to see is that if the Supreme Court doesn't accept oral argument, will the D.C. Circuit Court of Appeals stay all of the proceedings, or will it issue a mandate and then order that the case proceed to trial, and then that these issues will become appealable after there's a final judgment in the trial court, after there's a conviction or whatever the outcome will be. So we will keep you posted there, but that's what Donald Trump just filed, and wanted to give you a kind of thorough review. And I thought it was notable also that Trump just got his briefing with about 45 minutes left, so they were up late night on Saturday getting that filed. Well, I'm Ben Meiselas. This is the MeidasTouch Network. Hit subscribe. We're on our way to 2 million subscribers thanks to your support. Check us out at patreon.com/MeidasTouch and have a great day.
Thanks so much for watching. We're only a few subscribers short of 2 million subs. Please subscribe right now to the MeidasTouch YouTube channel for free and help us grow this unapologetically pro-democracy network.